This is a reading from the Code of District of Columbia, subsection 28.2-210, Delegation of Performance, Assignment of Rights. 1. A party may perform his duty through a delegate unless otherwise agreed or unless the other party has a substantial interest in having his original performer perform or control the acts required by the contract. No delegation of performance relieves the party delegating of any duty to perform or any liability for breach. 2. Except as otherwise provided in Section 28.9.406. Unless otherwise agreed, all rights of either seller or buyer can be assigned except where the assignment would materially change the duty of the other party or increase materially the burden or risk imposed on him by his contract, or impair materially his chance of obtaining return performance. A right to damages for breach of the whole contract or a right arising out of the assigner's due performance of his entire obligation can be assigned despite agreement otherwise. 2A, the creation, attachment, perfection, or enforcement of a security interest in the seller's interest under a contract is not a transfer that materially changes the duty of or increase materially the burden or risk imposed on the buyer or impairs materially the buyer's chance of obtaining return performance within the purview of subsection 2 unless or then only to the extent that enforcement actually results in the delegation of material performance of the seller. Even in that event, the creation, attachment, perfection, and enforcement of the security interest remains effective. But A, the seller is liable to the buyer for damages caused by the delegation to the extent that the damages could not reasonably be prevented by the buyer. B, a contract having jurisdiction may grant other appropriate relief, including cancellation of the contract for sale or an injunction against enforcement of the security interest or consummation of the enforcement. 3. Unless the circumstances indicate the contrary, prohibition of assignment of the contract is to be construed as barring only the delegation to the assignee of the assigner's performance. 4. An assignment of the contract or of all my rights under the contract or an assignment in similar general terms is an assignment of rights, or unless the language or the circumstances as in an assignment for security indicate the contrary. It is a delegation of performance of the duty of the assigner, and its acceptance by the assignee constitutes a promise by him to perform those duties. This promise is enforceable by either the assigner or the other party to the original contract. 5. The other party may treat any assignment which delegates performance as creating reasonable grounds for insecurity and may, without prejudice to his rights against the assigner, demand assurances from the assignee. As Section 28.2.609. And this reading is again from the District of Columbia, Codes of the District of Columbia, subsection section 28.2-210, delegation of performance, assignment of rights. You could assign your rights to whoever you got the contract from, or maybe a banker or something. Peace.